Assalamu alaikum and welcome to the Legal Matters Show with me, Ajaz Ali. And today I have a returning guest. I've managed to get Lubna Shuja, our guest from last week, the Vice President of the Law Society of England and Wales, back again and into the studio. Must be costing you a bomb coming here, for 2 weeks in a row. Right, Assalamu alaikum, Lubna, how are you?
Walaikum salam. I'm very well, thank you. How are you?
Yeah, good, thank you. Thank you for coming back.
Thank you for inviting me.
I thought I'd be cheeky and ask you to come back and see if you would, and it worked.
Yeah.
Right, today, so the topic's changed. We're not discussing you today. Just 1 second. Sorry, can you not? Is it too loud?
Yeah.
Okay, sorry. It's me, not the system. Right, I'll try and move it away from me a bit.
It's fine.
Okay.
It's fine.
Okay. So as I said, we're not discussing you today because we covered that last week, and it was quite an insightful show last week. This week, and we're not covering family law either, unless anyone has a question on family law or the topic we're going to discuss today. We'll be discussing wills, probate, and also powers of attorney. I think it's quite a relevant topic and a topic which, as Muslims, we should also cover. If anyone wants to get involved, then feel free to call the studio on 01902 972 150, or you can message us any questions you may have or any comments or suggestions you may have on via WhatsApp. The WhatsApp number is 07440 420 432. That's 07440 420 432. Right. As I was saying just now, Lubna, so today's topic is wills, probate, and powers of attorney. Now, I don't know whether you know, but as a Muslim, we must have a will in place. To be fair, I only got to know this a couple of years ago when I was researching for this topic, and from the research I've done, I have a little quote. It says that it is not permissible for any Muslim who has something to will to stay for 2 nights without having his last will and testament written and kept ready with him. That's apparently a taken from Bukhari. So as Muslims, we need to have a will in place, and that's one of the reasons I thought it was a topic that we must cover. Now, what is a will? So a will, in my understanding, a will is an instrument which you use to put your wishes forward, wishes which will entail what you want to gift or give, I should say, to whom upon your demise, upon your death. So there's various aspects of a will which I think we need to discuss. From kind of will be, well, how is a will legal? Can anyone write a will? There's various aspects. I think there's a few questions here, Lubna, which we can discuss if you so wish. I mean, I know we both got the questions, so I don't mind answering some, and if you don't mind answering some. First of all,
Well, should we just deal with the why, apart from the fact that Islamically you're required to have a will? Probably just explaining as well that if you don't have a will, you'll die intestate.
That's correct.
And that means that only your spouse or your close relatives or a civil partner will be able to inherit under your will.
Yeah.
And that's really important, because if you want to make sure that you're making a provision for your children or for perhaps even for your parents, if you don't put that in your will, it may not necessarily happen if you don't have a will. So I think that's really important. The
So
other
it's to
thing,
protect.
yeah, exactly right. It's to protect relatives that you want to look after, and you want to make sure they are looked after you pass away.
And it's to make sure that you protect your estate so that the relatives, I suppose, your relatives get as much of the inheritance as possible.
Exactly right. And in fact, for those people that may not be
Or the
aware,
loved ones, I should say, rather than just relatives.
well, yeah,
It's
loved
not necessarily
ones, loved
relatives,
ones.
is
It
it?
could be friends. It could be. I
Yeah.
mean, one of the other things that's worth pointing out is that if you die without making a will, and if you don't have any living relatives, your whole estate, everything that you own, everything that you've got, will go to the government. And, you know, so it's really worth it, especially if you haven't got relatives, you should make a will to make sure that you can, you know, the government won't get their hands on your property.
Yeah.
The other thing that's worth just reminding everybody, if they're not already aware, is the amount of inheritance tax. People may not realise that inheritance tax is charged at 40%. That's nearly
That's correct.
half. I
Yeah.
mean, it's so high. So the first £325,000 of a person's estate is tax-free. You don't have to pay tax on that. But everything else potentially is liable to inheritance tax of 40%. And I can't, you know, it's worth repeating that, because
It is.
people don't realise that until...
The problem is with our community. Well, it's not just our community. I think the community as a whole. People say that we need to plan, and they plan many things in life.
Yeah.
You know, they plan many things in life, but no one plan. Well, not no one, but not many plan for, you know, what will happen to all of this when I'm gone.
Do you know, Ajaz,
It's like invincible.
in UK, I mean, this is quite a shocking statistic, actually. 60% of adults do not have a will in the UK. 60%. I mean, that's
unbelievable, isn't it?
really, really shocking. And there was some research that was done by an organisation in London. I think it's called Royal London Research. They found that 16% of people who are over 55 and who have a home and, you know, they own a property, they don't have a will. So they've got a property and they don't have a will.
Yeah.
And, you know, that property could be worth... I mean, nowadays, most properties are...
Well, look, even in where they used to be like 40, 50,000 pounds, even those are no longer 40, 50.
Exactly.
At least, you know, 70, 80. So,
yeah.
so an average house is probably, what, 250?
I was just going to say that.
Yeah.
I mean, actually, the band before tax is chargeable is 325,000. And actually, if you've got a property, you've probably eaten most of that, if not all of it already.
Definitely.
Let alone any savings. And, you know, we haven't even talked about, you know...
Investments and savings.
Exactly, investment, savings. You know, and especially within the Asian community, people have property abroad.
They do.
They have assets abroad. And all of that's going to go into the pot.
Yeah, it is. It is. That's absolutely true. However, I think when you mention assets abroad, I'm not too sure whether... Well, I don't think the assets abroad can be covered in the wills here. I think you'll have to take out separate wills for assets abroad.
Yeah, I mean, I think you can actually make a will in the UK, which is a multi-jurisdictional will. They call it multi-jurisdictional, which means it will cover your assets everywhere. You'd have to go to a solicitor to make sure that's been done properly.
Yeah.
And that solicitor will need to be somebody who knows how the laws in the land...
that particular...
Exactly, how they operate... But really, you know, you may find in some countries, you know, you need a will in that country and you also need a will here so that your assets over there are covered under whatever their law
What's
is.
funny is that the will made in England and Wales may not be relevant in Scotland.
Exactly.
Either. So,
Oh, really? Okay, I didn't know that.
yeah, because it covers just England and Wales.
Yeah.
That is something I read somewhere. Not that I've tried to apply that yet, but that's take that as my opinion.
I mean, the other thing also, talking about foreign land in, you know, foreign assets and land abroad, another thing that people need to think about is, where are you domiciled?
Yes.
Because if you're domiciled in the UK, then your worldwide assets will be subject to inheritance tax.
Yeah.
Whereas if you're domiciled abroad, then only your UK assets are subject to tax.
Tax. Yeah.
So there's all sorts of considerations that people, it's not just about let's get a piece of paper and write down what we want to put on it. There's a lot of stuff people have to think about and
Well, we've been talking about assets, but in a will, it's not just assets, is it? It's your wishes, such as where you want to be buried, if you want to be buried.
And who's going to look after your children?
Your children now.
Yeah,
That's the
very,
big one.
Very important.
If you have either children or vulnerable others,
Yeah.
Then who's going to be guardian?
Yeah.
So all of that needs to be taken into account. I mean, yes, when we're in our 30s, 40s, we think that
we're going to live forever.
We're going to live forever. Yeah, we don't think about these things, but it is something that we need to think of. Even if you're young, even if you're 18, I think you got to think of your future.
If you've got any assets at all, and I'll tell you, actually, it's a really good point you've just made about being 18, because one thing that people don't do, and they absolutely should do, and it's a fairly relatively new concept, I think, digital assets. So when you make a will, you should make sure that all of your digital assets are included as well. So where people say digital assets, people might say, "Oh, what the hell's one? What's a digital asset? What does that mean?" So how many of us don't have photos stored online? You upload them to the cloud or you upload them to whatever.
Well, for our advert thing, I downloaded yours from the internet. So yes, it's there.
So first of all, online photos.
Yes.
Everybody nowadays, you use your phone to take pictures, and then you download your pictures either to a local device or some people will upload them to the cloud. You've got social media.
Yeah, who takes control of that?
Exactly, who takes control of that? You've got your email accounts, which often will have a lot of important information that your loved ones will need after you've passed away. It might be to do with, I don't know, bills. It might be to do with your work, your business, all sorts of things. So you've got your email, you've got your social media, you've got, any online assets, photos, whatever. And also, nowadays, people dabble in cryptocurrency.
Yes.
So you haven't got a bank account and hard cash for that.
No,
That's
no.
all money that's on the web or however you want to call it. And we Law Society did a bit of research on this, and it's really interesting because those people that had made a will, 93% of them did not include anything about digital assets in their will. 93%, and most of them didn't know. People that we'd asked, they had no idea what would happen to their digital assets when they died. So what people need to do, it means that in your will, or, you've got to make a provision in your will that somewhere there is a record of your online passwords so that your loved ones are then able to access your digital assets. I mean, you imagine, people take pictures of their loved ones.
They do.
They're all going to get lost if nobody can access them.
Yeah, absolutely.
When you pass away, that's it. They're
That's
all
gone. It's gone with you.
Memories all gone. And they're really valuable memories. And, that's the kind of... So just to flag that up, that, another reason why you should have a will is to make provision for your digital assets and to make sure...
If providing for your children and providing for your spouse is not enough, your digital assets...
Well, in this day and age...
what takes priority?
Exactly. I mean, your LinkedIn profile,
That's it.
Your face... Mind you, people may not want to give access to their face, but I mean, you choose what you want to give access to.
Well, saying that, it's only last week on Facebook, I am on Facebook, I saw a birthday come up of a old friend of mine who's passed away.
Oh, really?
And because his account is still active, no one's bothered doing anything. So his birthday came up, and then people started commenting, and no one's taken control of that. No one, I suppose, his family could do if they want to.
Well, they might not know the password. They can't probably log in.
I think nowadays you can, with Facebook at least, I saw something pop up on my phone once. I could link it with someone so that if I pass away, they could access it.
Oh, is that right?
Yeah,
Okay,
yeah.
I didn't
So
know
that's
that.
something else people
It's probably
should.
the same with other accounts then. I don't know,
Yeah,
your
they should be.
Twitters, your Instagram, your LinkedIn. But, you've got to think about these things. It's really important to think about these things as well as your traditional property, savings,
Yeah.
investments,
Absolutely, absolutely. Um, so with the will itself, how does it work? Does it need to be witnessed?
Yeah, it absolutely has to be witnessed. I mean, otherwise,
Or can someone just write, I want to do this, and
well, they can write what they like, but it probably won't be it won't be valid.
Valid,
You
yeah.
can write whatever you like; it won't be valid. I mean, in order for a will to be valid, it has to comply with there are legal requirements.
Yes.
And the legal requirements, the very, very basic legal requirement is the person that's making the will has to sign the will alongside in the presence of two witnesses.
so one person can't
No,
witness
they've
it.
all got to be there together,
Okay.
witnessing a will together.
At the
I mean,
same time.
having said that, I say that because of the pandemic, there was a new provision for remote witnessing of wills, which was it was just because during the pandemic people
Yeah.
could not get together and do witnessing. So what happened was it meant that people didn't have to be physically present. And they could witness through technology.
Yeah.
And that provision is actually still in place until the 31st of January 2024. And that's because people are, there are still vulnerable people that, they have concerns about going out and about and they want to self-isolate or they might need to self-isolate. So there is a provision for remote witnessing of wills for vulnerable people. But generally, the rule is that the person making the will has to be present alongside two witnesses, and they've all got to sign in front of each other in each other's presence.
That's fine. I mean, we previously had a matter on with a client whose father had passed away, and the father in his later years married again from abroad, and she came over here. And anyway, in the will, he had left some stuff to the wife, some stuff to the son, something to the daughter. But then apparently when he was not so well, another will came about. Another will came about, leaving everything to the wife. So our client was the son, and he wanted to challenge it. So we took it further, and it just so transpired we checked with the witnesses, and their stories weren't adding up.
Of the second will?
Yes, as
Yeah.
to when they witnessed it, was everyone present? Because one of them said, "Oh yeah, such and oh he bought it to me and I signed it." Okay, was the other person there then? No. So
Not valid. Not
yeah,
valid.
not
Will's
valid.
not
So
valid.
we've come to an agreement with them now.
I mean, actually, just on that point, Ajaz, going back to why you should make a will, it's also about making sure that you can minimise anybody contesting the will later.
Yes.
Because the clearer it is,
Yeah,
if it's done properly, if it's done clearly, if it's done through a solicitor, particularly because they will make sure it complies with all of the relevant legal requirements, there's less chance. I mean, you can't say there's no chance. There's less chance that it will be contested later. I mean, nowadays, the number of contested wills are really, really high.
that's correct. We've got 2 or 3 on at the moment, where in fact in each of them we're acting for the person we feel is in the right. They're not the one contesting. Well, I'll say that one of them was, but the rest aren't. But they're the ones who the main beneficiaries as well. But obviously, if it's not normally it's the children who contest if someone outside the family gets something.
Or if one child
Gets more than
all of the others,
Yeah.
then you often. I mean, I'm a mediator as well, and a lot of my mediations are on what we call contentious probate, which
Yeah.
basically means where somebody's passed away and there's a will, and they're all arguing about who should get what.
Yeah.
And who should or shouldn't get what. And I mean, one of the things that can be helpful with that is if if somebody wants to make a will and they make a conscious decision that they don't want to include somebody in their will, so they may have a child that they consciously think, you know what, I don't want to give that child anything because of X, Y, Z, whatever may be going on within their family circumstances. And often what we will recommend to that person is make your will to, however you want to make it and whatever you want to put in it. But it might be worth you writing a side letter, which is kept with the will, in which you explain why you've excluded a particular child or relative or person. Because later, then, if that child comes and contests the will, at least there is a letter that was written at the time that your will was written, expressing and explaining why you've done what you've done.
No, that's a brilliant
and
idea.
that will be helpful later when it comes to contesting it, to understand what was in the mind of the person making the will at the time.
And that will actually save a lot of hassle and also money.
Yes.
Because sometimes, half the estate goes into fighting and contesting the will.
That's right. Absolutely.
That would save a lot of hassle. And
well, do you know, we again, back to a little bit of research again, people that have died without making a will.
Yes.
So average amount it costs to sort out a situation where somebody's died without making a will is £9,700.
Yeah. That's a lot of money.
That's nearly 10 grand,
of
your hard-earned cash just to sort out what's going to happen because you did not make a will,
which would have cost you 100 and something odd pounds.
Well, I mean, I don't know.
Whatever.
It depends on what the situation is, but compared to the cost of sorting out the situation, it's just a no-brainer.
Absolutely. So moving back to when we mentioned the witnesses, so can a family member witness, or can the executor witness the executors or beneficiaries?
A beneficiary cannot witness a will.
Okay.
So if you've got anybody under your will who you're leaving a gift to, they cannot witness a will. Okay. Whoever that is, they should not be a witness, and it's not going to be valid if they are. An executor, who is the person who is given the job of sorting out your affairs when you pass away. So they've got to apply for the grant of probate. They've got to basically do what you've asked them to do in the will. Yeah. They can witness the will as long as they're not a beneficiary. Okay. As long as they don't get anything under the will, they can witness it.
Okay, that's fine. So, and we've already covered. Like, I had a few other questions written here about siblings, etc., contesting, and we've already kind of covered all of that.
Yeah, siblings often do contest the. I mean, but having said that, it's not just siblings that contest the will. Anybody can contest it, and literally anybody, if they believe
that
they've got a right, or if they believe that they were a dependent of the person who's passed away.
Yes, that's happened before.
They can, there's a Inheritance Tax Provisions Act. No, not Inheritance Tax. Inheritance Act. I can't remember what the title of the thing is now. But anyway, there is a provision for people who believe they are dependents of somebody who's passed away. If they feel that they have not been provided for under the will,
as they were during
their lifetime, then they are they can contest the will. Yeah, are you just looking up the act for me because I can't remember what it's called.
I was looking to see if I've got it somewhere.
Straight out of my head, I don't know why I should know that.
Well, that's fine. So who can keep the original will then?
So the original will, when you apply for grant of probate, when you apply for grant of probate,
Tell you, hold that thought.
Yeah, after the adverts.
Yeah, we'll come back to this question after the adverts, guys. Again, if you want to contribute or if you want to join in, give us a call on 01902 972 150. Thank you.
The death of a loved one is a very emotional and challenging time for the family members of the deceased. Al Mu'min Funeral Services have been supporting families across the UK since 2005. Their professional, experienced and quality service ensures the whole process from release from hospital to burial is taken care of respectfully and efficiently. They also specialise in worldwide repatriations, assisting to take loved ones to Pakistan, India, Bangladesh, Iraq or anywhere worldwide. almu'minfunerals.co.uk, your trusted funeral service.
Do you have a family member that's passed away and you would like someone to assist you in legal advice? Kenneth Jones Solicitors has been providing legal services for businesses and individuals since 1986. We specialise in probate, Islamic wills and family law. We also offer services in conveyancing, immigration and personal injury. Contact us today on 01902 745 773 or visit us on our website at kenneth-jones.co.uk.
Betsy's Burgers taste flippin' awesome. Betsy's world-famous burgers are coming soon to Wolverhampton and Wednesfield. Prepare for sizzling hot smash burgers, bubbling mac and cheese, and sensational sides. Betsy's is home to undefeated, crispy on the outside and fluffy on the inside fries. Dunk your Betsy's burger in a lava-hot melted cheese and get a load of our loaded fries and mouth-watering cheese-filled onion rings. The king is dead. Long live the queen. Betsy's Burgers, coming flippin' soon.
Eurofit Auto Centres, the West Midlands' leading independent auto centre, celebrating 18 years of service. All services, MOT and repairs, with a free collection and drop-off service within Wolverhampton. Book online today at eurofitautocentres.co.uk or call us on 01902 40 40 45 and we'll direct you to your nearest branch. The experts making vehicle repairs simple.
Are you in receipt of benefits and looking for cavity wall or underfloor insulation? Did you know, with Northern Gas Heating, you could get a free boiler with the insulation measure of your choice? Call 0800 083 1000 or go to northerngasheating.com to see if you're eligible. It's a quick and easy assessment. Northern Gas Heating, celebrating over 20 years in the industry. We're proud to be the UK's local central heating company.
Feeling peckish? Treat your taste buds with a range of delicious snacks and flavours of the Far East from Indus. Why not try our range of roasted nuts, dried fruit, Bombay mix and flavoured snacks? Indus by AIB Foods. Available in your local supermarkets and varied retailers. Indus, the world's finest foods.
Khan Builders offer a full range of building services, from major rebuilds to small projects, home improvements, kitchen fitting, plastering, bathroom fitting, extensions and much more. We pride ourselves on providing a professional, caring and high quality service and always meet our customers' needs. Contact Khan Builders today on 07813 950 265 for a free quotation from Khan Builders.
Pack Continental, your local best halal supermarket in Wolverhampton. Established for over 20 years, we pride ourselves on our fresh vegetables and fresh fruit. We have a variety of spices and lentils. We're also an award-winning Halal Butcher of the Year for 2 consecutive years. We supply excellent quality meat and poultry delivered fresh daily to our store. Visit us today at 1-3 Hunter Street, Wolverhampton, WV6 0QZ, or call 01902 717 792. Open 9 a.m. till 8 p.m. Monday to Saturday and 10 a.m. till 6 p.m. on Sundays.
Do you need planning permission and don't know where to start? Whether you're planning on extending your family home or building a new one, Footprint Design Architects are here for you. With a broad range of experience in residential, commercial and industrial architecture, we pride ourselves in offering a unique, tailored service for all our clients. For more information, visit our website www.footprintdesign.net or contact us at info@footprintdesign.net.
Ramadan's blessed days are the perfect opportunity to reach out to suffering families in the Ummah with our charity. You can do so by donating to one of Ummah Welfare Trust's many projects which are helping our brothers and sisters in Africa, Asia and the Middle East. In these difficult days, charity is one of the best ways to earn Allah's pleasure and protection. To give yours, call 0800 4 0800 11 or visit uwt.org.
This is Ramadan Radio, your local voice, your local Muslim radio. Go to RamadanRadioWolves.com and donate to your local mosque.
Assalamu alaikum. Welcome back after the break. Hope you enjoyed these adverts. I'm sure my firm's on there as well somewhere. Right, you're listening to the Legal Matters Show with me, Ajaz Ali, and with me I have Lubna Shuja once again. So before the break we were discussing wills, and we'd got down to, I think I'd asked you, Lubna, who can keep the will.
Yes. Yeah.
So I think you were about to explain that and then we went into the break.
Yeah. So the original will is stored by the person who's made it, or sometimes their solicitor might look after it for them. They might charge them a fee for it. It depends.
Depending on, yeah.
But the original will is usually kept by either the person who's made the will or their solicitor. And the person who's made the will should make sure that their loved ones know where the will is.
Where it is, yeah. So
because
in a time of need,
yeah, exactly,
they can get it out quite easily.
Yeah,
located.
Yeah. Can I just say as well, just before the break, I was talking about dependents who can make a claim, and I couldn't remember the name of the act. So the name of the act is Inheritance Act, Provision for Family and Dependents Act, 1975. So under that act,
Yes.
anybody who was provided for before the person passed away, who isn't provided for under the will, can put in a claim to say, well, they've forgotten me, they've missed me out, I'm entitled to be looked after.
Well, whilst we're on the subject of entitlement, I think another thing that we mentioned during the break was if someone has had a nikah in this country, so a nikah abroad and then come into this country, that's different. But if they've had just a nikah here and they've not actually had the marriage registered, what will be the legal stance as far as if they die intestate without a will?
So if the person dies without making a will, their Islamic wife or husband will not get anything, because a nikah, if both parties live in the UK, a nikah alone is not a recognised marriage in this country.
As long if it's happened here.
If it's happened here and both parties live here. So you must have a civil ceremony, a registry, and be a registered marriage in England for the partner, the spouse, to inherit anything under intestacy. That's another reason why it's really important to have a will. So if you haven't had a civil ceremony,
then you definitely need a will.
Absolutely need a will. Otherwise, your spouse is not going to get anything.
It will go to other family members, but not to your spouse.
Yeah. And actually, also, you've got to think about, in this day and age, often you have blended families.
Yes.
And if you're in a situation where you've got a blended family, again, rights can be different depending on who those family members are. So if you've remarried and you've got children from
previous marriage
or stepchildren, or you have to think about all of them, because they won't automatically all get anything on intestacy.
Yeah. Okay.
If you don't leave a will.
That's quite insightful, actually. I think that's another reason why it happens quite a lot, where nikahs happen, but no one's they've not bothered to register the marriage, thinking, well, Islamically we're married, but the law of the land doesn't believe in it.
Right.
So the law of the land must be followed.
That's right. Yeah.
So who's responsible? I think we've discussed this already, actually, as to who's responsible for distributing the, distributing and paying anything that's in the will to the beneficiaries. It's normally the executor.
Yeah.
Normally people have an executor and maybe, or two executors, and maybe a stand-in executor as well, a third person who, if, for instance, the first ones can't, or for any reason, maybe they're not around, then then another executor can stand in. So
And your executor can be a solicitor as well. So
Yes.
if you go to a solicitor to have the will prepared
drawn
by
up.
them,
Yeah.
often
I'm an executor
yeah.
on a fair few wills, to be honest.
yeah, yeah.
So it is a headache sometimes.
But you know, at least if you've got a solicitor doing it for you,
Yes.
they know what they need to do. They know how to
Yes.
get the probate sorted out once you pass away. They will have a copy of your will there. So it takes the burden off your loved ones who may well be grieving, and that's another burden for them to have to deal with on top of everything else.
That's very true.
Whereas if you've got a solicitor dealing with it, then you can just let that solicitor get on with it.
Sometimes I recommend to people that maybe not your children, maybe try and make, if you've got a close friend, maybe try and make that close friend, if you're not going with the solicitor option, that close friend, because they're a bit detached from, because likelihood is they're not a beneficiary.
To take the stress away from the
Yes.
children. But
Yeah.
it would have to be somebody you could trust implicitly.
Yeah. Well, more than likely, if whatever happens, even that friend will more than likely go and see a solicitor and leave it in the solicitor's hands.
Yeah.
And say,
Yeah.
can you deal with this for me, please?
I mean, I think what I would say is, the bigger the estate, it's always a good idea to have a solicitor doing it for you. For some estates, you might not need a solicitor to
Yes.
deal with it. So if you've only got a spouse and you're leaving everything to the spouse, and if most of your assets are joint assets anyway, in some situations you might not need to apply for a probate. So say, for example, if you've got a bank account in joint names, some banks just with a death certificate will transfer the account to the surviving spouse without a probate. But
That's correct.
it depends. I mean,
It's also
it
the
varies.
case. Also the case when with a property, if the property is in joint names,
Yeah.
as joint tenants
Yeah.
rather than tenants in common. If it's joint tenants, then it will automatically go to the surviving tenant.
Yeah. And all they need to produce is the death
Yeah,
certificate.
exactly. But the downside there is if, for instance, you buy a property with a friend or another relative, and at that point you've put it down as joint tenants, and you're thinking that my share is going to go to my wife and children, or husband and children, and it's joint tenants with someone else. That's where there'll be contention then, because
Yeah, I
it'll
mean,
automatically-
this goes back to going to make sure you see a solicitor, so that a solicitor can advise you at the time that you're buying the property how you should own it.
Exactly.
To
But
make sure.
what I tend to do when someone does come to see us for a will, first thing I ask them, is the property in your name solely? Is it in joint names? Even if it's joint names with your spouse, okay, you still, in order to get this will, have a valid will, you need to sever the joint tenancy. So we end up
We're getting all technical now, aren't we?
Yeah.
Ajaz?
So a few legal words that I know.
Yeah.
Right?
No.
So basically, you have to change it from joint tenants to tenants in common, so that you can then each have a share
That's
of the
right.
property. Right. Anyhow, I think we've spoken a lot about wills now. Shall we move on to the other topic? One of the other topics. I'll let you choose. Shall we move on to probate
Yeah.
or powers of attorney? Because I think, I know you're
Perhaps
probably
do a little bit on both.
yes. 'Cause we've only
bit on
got
both.
just over 15 minutes left, but so let's try and cover both to some degree. And if anyone wants any further information, they can either contact me directly or contact you directly.
Absolutely.
So, I mean, they can get the details from put our names in Google and it'll come up. I think yours comes up right at the top.
I don't know. I haven't checked.
So, if we move on to probate first, then, though we covered a little bit about probate that because it intertwines with wills. So, probate is when once someone's passed away, and they have assets, and in order to access those assets, you need to apply for probate to the probate registry. there's a small fee. The probate registry charge, I think, 80 to 84 pounds, something like that. I can't remember the exact figure off the top of my head. But the application, depending on the number of assets and depending on how complex those assets are, because you mentioned digital assets as well.
Yeah.
All needs to be, all
and
that
assets
information,
abroad, possibly.
all of that needs to go into the application form, and you need to work out, okay, is there going to be any inheritance tax on it as well?
And that needs to be paid within 6 months after the person's passed away.
Yeah,
Otherwise, the revenue will start charging interest.
yeah.
So there's like a period that you've got to get your inheritance tax paid. If
The
it's
funny
due.
thing there is that at one time during lockdown, it was taking more than 6 months for probate to come through.
But you've still got to pay your
You
taxes.
still gotta pay
within
your
6
taxes,
months.
yeah. So,
Because that's got to get paid before you can get the grant of probate. So the grant of probate is a document
yeah,
that you produce for
to gain access to
yeah,
the
to transfer assets and to do anything that you
Yeah.
need to do with them. Yeah.
So first of all, when you do apply, does your original will get returned?
No, the original will, once you've applied for a grant of probate, it becomes a public document. So the probate registry will keep it, but you'll be able to get a copy of it if you need a copy of it.
Okay.
Yeah.
Okay, so you get a copy, but they'll keep the original. Okay.
Yeah. You have to send the original to them to get the grant of probate.
So can you sell a house before probate?
You can put it on the market.
Yeah.
You can start trying to get viewings and things like that in, but it's unlikely that you will actually be able to sign any contracts or documents until the grant of probate has come through.
That's we've got a few going through at the moment where we're waiting on probate, either from the other side or from us. But
Yeah, I mean it takes time, doesn't it? You want
Yeah.
to, if you want to put the house on the market and start seeing what the interest is and see if you can get any offers in, you can get the ball rolling and start getting things in place. Yeah.
Right, and it can, well, as far as the executors are concerned, so if there's more than one executor, do both of them have to apply for probate?
No, not necessarily. No, one can do it if they have the consent of the others. Then one can apply for the grant of probate, but you can't have more than 4 people applying for it.
Okay.
Normally, you'd get 2. That's the normal way to deal with it. Is you get 2 executors so that
Yeah.
they're both dealing with things together.
Normally, I think when people go for their children, they then trying to assess which of my children is the most wisest.
Well, you might have a solicitor and one
And one of the children,
and one,
yeah.
a child or a relative
Yeah.
with the solicitor. So the solicitor does all of the actual paperwork,
Mm-hmm.
but you've got a relative who's making sure that they're keeping an eye on how quickly things are progressing.
So, is there a figure whereby, if the estate is worth a certain figure, that it must or you should go for probate?
Yeah. So if the estate is worth £10,000 or less, then it's unlikely that you're going to need to apply for a grant of probate. Those assets can probably be dealt with just a death certificate.
Just go to the bank.
Exactly.
And yeah.
Most banks and institutions will accept a death certificate if it's less than £10,000 savings.
Yeah.
But if it's more than £10,000, then yes, you would need a grant of probate, most likely.
So
And we've talked about if assets are owned jointly, then you might not need probate for that.
yes.
So we've talked about that
Yeah,
already.
yeah. So, right, I think we've covered most of, unless you think there's anything else to cover in probate.
No, I think we've covered most of it. Yeah.
Is there a threshold? We've discussed that there's a threshold. Shall we move on?
Just on the executor's point, when it comes back to making will, if you've got assets abroad,
Yes.
land or property abroad, you might want to think about having an executor who's abroad,
Goes abroad.
so
Make
that
it
they
easier.
can deal with things in that country easily, rather than having people in the UK who
Yeah.
might struggle.
Yeah, absolutely.
Yeah.
Absolutely. I think another thing with assets abroad, which I've noticed from my own family actually, I'll give you that as an example. My grandfather passed away in the 90s. And to this day, my grandfather's land is still on his name.
Oh, really?
My grandmother's gone since then as well, but the land is still on his name.
Goodness.
It's because one of my aunties also passed away, and then her kids were a bit young. Her husband we didn't get on with,
Oh, no.
and they can't be well because of conflicts, etc. The land is not being transferred, so all this must be taken into account when people are thinking of their future. Well, they should be thinking of the future. They should think, okay, what's going to happen to my land here and property here, my assets here and assets abroad? It's we can't just leave it to the kids to fight over later. So, my uncles and aunties and my father, they've not done anything about it. Well, my father's,
How long ago was that?
as a 90s, in the 90s.
Goodness me.
So what my father's done is he knows exactly how much he would be due. So he's gone and built a house on top of a site which he says, well, this is not mine now. The rest of you can do what you want.
It's not ideal, though, is it?
No, it's not
really the
ideal.
way to-
It's not ideal.
Because
But
actually, the land he's built the house on is not in his name.
no, it's not. It's not. But he's got qabza over it. That's how he's
Yeah,
thinking anyway.
yeah.
Anyhow.
Another reason why you should make a will.
Exactly. So moving on to powers of attorney. So, I mean, first of all, I think I'd like to explain what a power of attorney is. So, in a power of attorney, again, is another instrument which gives a person power over another person. It can either be over their property and finance, or it can be over their health and welfare. So there's two powers of attorney you can go for. It's a lasting power of attorney with either health and welfare and property and finance, two separate applications. Now, some people go for both. Some people go just for property and finance. The reason for that is, in my opinion, I'll tell you what. Once you have those attorneys, you have the ability to make the decision on behalf of that person. So, a lot of people, as they get older and more fragile, they can't go to the banks, etc., to pay the bills or do any financial transactions, or deal with their day-to-day, even groceries. So if someone has a power of attorney for them, they can then get that money from their account, pay for whatever needs to be paid, and look after their financial interest. As far as health is concerned, again, the power of attorney for health and welfare is for them to be able to look after their health and welfare, as it says clearly on the tin, as they say. Mm-hmm. But sometimes people say, well, will my son or whoever make a better judgment than my doctor on my health and welfare? And the honest answer is, well, maybe not. So then some people don't actually go for that one. But there is more to it than just the doctor's opinion. And then there's also deputyships, which come into this slightly, but it's harder to get a deputyship. And deputyship is once someone's lost their mental state, so that they're not compos mentis, meaning they do not have memory loss, etc. All comes into the same compos mentis.
Dementia.
That's the word.
Yeah,
yes.
Yeah,
so if they got dementia, they can't get a power of attorney.
Alzheimer's, that kind of thing.
Yeah.
Which is,
if you have Alzheimer's or dementia or anything to do with even if you're losing memory for a small period of time, you won't be able to get a power of attorney. You then have to go for a deputyship. So,
but if you think ahead,
if it works before that stage,
if you're worried about what might happen to you, if you're worried that you might get dementia, or you're worried that you might be not able to manage your affairs by yourself, you can plan ahead.
And you should plan ahead.
Yeah.
And I think anyone making a will should at the same time really be looking at making a power of attorney also, putting a power of attorney in place so that if anything happens to them or they can't, because with a power of attorney, it doesn't necessarily mean that that person will have full control over you. You can revoke a power of attorney, but at least you have something in place so that if anything does happen, they have the power, the authority to act on your behalf. So even down to selling a property, etc., or transferring a property, that power of attorney will cover it. So that, in essence, is a power of attorney. I don't know what else to explain about a power of attorney. Shall we? Well, I'll ask you a question as far as power of attorney is concerned. Can a power of attorney transfer money to themselves?
The key issue is it in the best interests of the person who's given the power of attorney?
Absolutely.
So if you're transferring money to yourself because you need to spend it for that person's benefit, then yes, you can transfer the money to yourself. The critical issue is it in their best interests?
Do you see the common ground between child law and powers of attorney? I suppose one of the reasons for powers of attorney is because you're assuming that the person is a bit fragile, just like a child is a bit fragile.
Yeah.
So it's always about the best interest.
But I mean, it's just worth pointing out that, you know, if attorneys are transferring money to themselves, there's a very fine line between, you know, where there's a conflict of interest, because actually, you know, there could be a potential conflict in that, you know, in what they want and what the person that they're looking after wants. So it's got to be in their best interest. That's the really critical issue.
That is, and if it's not in their best interest,
you shouldn't be doing it.
You shouldn't be doing it. And in fact, if you can be reported, and prosecuted. So it has to be in the best interest of the person who you have power of attorney for. So can a family member override a power of attorney?
The actual person who has written the power of attorney can always, as you said earlier, they can always revoke it. They can always change their mind and say, you know, no, I don't want to give a power of attorney to this person. But for other relatives, you know, they might be worried about a close family member abusing their rights or responsibilities by, you know, not looking after the loved one properly. And actually, there is actually, just on this point, one of the things that we've been seeing more and more happen, more recently, is where somebody has got a power of attorney and they're abusing that power. They're not using it for the best interests of the donor, or they're neglecting the person that they should be looking after. And this is an issue that, you know, it does really need to be addressed. So if there are relatives that see that happening, they need to report that. They need to take it further.
They can take that up with the Office of Public Guardian, I'm assuming. Right, okay. Is there anything else that you want to add to this? I mean, we've got just over a minute left. So.
I think just stress again, really, make a will. It's so important to make a will. And, you know, if you don't make a will, you're leaving so many problems and stress and anxiety for those behind. And I'm sure that's the last thing most people would want to do, that when you pass away and they're dealing with a bereavement already, the last thing you want them to do is then have to start arguing about who's going to get what.
Absolutely. As they say, where there's a will, there's a way.
Well, you know, it's a human nature.
Yes.
The mediations that I do, you see what comes out, what people, how they behave when there's money up for grabs.
Absolutely.
It's very sad.
Right, guys, we'll bring this to a close. Thank you for supporting us this Ramadan again. We will be, inshallah, back next year. Thank you, Lubna, for joining us this week and last.
Thank you very much. And just Eid Mubarak to everybody.
Yes,
who's
Eid Mubarak
listening.
from us all. Eid Mubarak, and I hope the remainder of Ramadan goes well for you guys. Lubna, good luck in your future. In October, inshallah, you become president.
12th of October, inshallah.
Yeah,
Thank
inshallah,
you.
we'll
Thank
be
you.
rooting for you. And
first Muslim, first Asian.
mashallah, very good. Very good. Thank you.
Inshallah.
Allah Hafiz.